Hi, Cora Stack here. Here I am again, and I'm talking about something that's very important, and that's the separation of powers and the roles of the President and the Attorney General in elections. So I just want to, we'll focus in on Ireland, but these issues are international. They're international, and the patterns that we're seeing in Ireland are mirroring what's happening in many Western democracies. So this is more of a Western democracy argument than it is a democracy argument than it's that's the fascinating thing about it. Absolutely, in terms of examining the issue, it's a global democratic problem, really, or erosion of democracy, and this is how it's happening. So let's just look at how it's happening in Ireland, but to be very clear that it's a global phenomenon happening in the same way, and perhaps Ireland is mirroring what is going on elsewhere, or what's going on elsewhere is considered normalised behaviour or normalised practice, and this normalised practice has been imported into the Irish systems in some way, as a lot of things do, and we just have to just examine whether this needs a good examination, an analysis and a critique, just for to try and see why this is happening, and what's causing it to happen, and how this trend can be reversed, so just let's be very clear that this is a global phenomenon, but we're focusing on Ireland at the moment. So why this matters in Ireland? Most people in Ireland believe our democracy is protected because we vote regularly and have a written constitution. Now, most people don't even know the articles of the constitution. This is something that I've translated into plain language because I think this is very important, and everybody really should know their constitution. But it's so opaque and written in such kind of language that a lot of people don't know their own constitution, because it's not taught in secondary schools, which again I think is something that should be looked at. But elections alone do not protect democracy. They decide who holds power, and more importantly, not how power is constrained. The constraint comes from the separation of powers set out in Bunreacht, the hÉireann, that's the Irish constitution. This system still exists on paper, but in practice, this is the point, and not just in Ireland, but across Western democracies, it's been quietly weakened or eroded, particularly in electoral context, where constitutional review is extremely limited and where accountability can be lost forever. In fact, it's hugely limited from my research. To understand this properly, we must be clear about where power actually sits, including the often misunderstood role of the President and the Attorney General. The core separation of powers in Ireland is like a system. That's how I see it now. The Irish Constitution divides state power between three branches. The legislature, the Oireachtas, they make the law. The Oireachtas make the law. That includes the Senate and the Dáil first, and then the Senate. Now, the Senate have limited powers in terms of making the law. It's the Dáil really are the primary, but the Senate have they can suggest amendments, but they're not the last. The last part of the enactment of laws lies with the Dáil, not the Senate. But the Senate have certainly powers to make various comments on during the enactment stage of legislation or amendments and such, but it's the Dáil that ultimately decides whether those will be included or not in the final acts, as I understand it. So the executive is the government of Ireland. That's the executive, which implements policy and administers the state. Then there's the judiciary, which comprise the courts, with the Supreme Court of Ireland at the apex, which interpret and enforce constitutional limits. So we have the district court, then we have the circuit court, they have their responsibilities and duties. Then we have the high court, and certain cases can be started in the district, others only in the circuit, others depending on the complexity at the high court, then the Court of Appeals, that's relatively recent, and then there's the Supreme Court. So that's been there obviously from the beginning. No branch is supreme. That's the whole idea of it. The Constitution, that's the system. The Constitution deliberately fragments authority. This was the original design of the Constitution, so that no single actor controls lawmaking, execution, and the interpretation at the same time. The fragmentation is the core protection against abuse of power. Now, people would say that's one thing. You'd hear people say there's abuse everywhere these days, and abuse of power everywhere, and there's unchecked power. Now, why is that happening? I am suggesting that perhaps this is because of the weakening of separation of powers. This could be one reason. This is just a hypothesis. The weakening of separation of powers is contributing to unchecked power, and so that, in other words, the fragmentation is the core protection against abuse of power. And people would say in Ireland today there's no accountability. And this is extreme, perhaps, or there's a huge amount of abuse and abuse of power. Where the President fits in the separation of powers. This is important too to understand. The President of Ireland occupies a unique constitutional position. The President is not part of the executive, does not govern, and does not participate in elections or political campaigning. Instead, the President functions as a constitutional guardian. Key powers include signing bills into law, referring bills to the Supreme Court under Article 26, if there's any issue with those bills, and if there's any red flags or anything to do with those bills that they could be in any way, controversial or unlawful in the future or anything like that, referring bills to the Supreme Court under Article 26, safeguarding constitutional integrity rather than political outcomes. Importantly, the President's role is reactive, not proactive. Now, rarely does the President, in theory, the President would have his or her own legal advisors, but for certain acts, there would be the President would decide, I suppose, based on the legal advice, to refer the matter to the Supreme Court. Otherwise not. So not all, but usually that's announced in the media as to which ones are referred to the Supreme Court for their adjudication, which are not. The President cannot interfere in electoral processes, cannot supervise elections, and cannot initiate constitutional challenges about elections independently. The power operates before the law takes effect, not after elections are run. So let's look at the Attorney General's constitutional role. The Attorney General of Ireland occupies a very different position. The Attorney General is not a judge, is not independent of government, and is constitutionally aligned with the executive. The role is to advise the government on constitutional legality, represent the state in litigation, and defend enacted laws and executive action. Now, I would look at this. Advise the government on constitutional legality, represent the state in litigation, and defend enacted laws and executive action. So let's go to that again. The role of the Attorney General is to advise the government on constitutional legality, to represent the state in litigation, and defend enacted laws and an executive action. Crucially, the Attorney General does not represent the public, but is a key advisor on constitutional legality. That's the important point here. His job is to advise the government on constitutional legality. That's very important. Crucially, it does not represent the public. Yes. So, but he is a guardian of the Constitution in the sense that his role is to advise the government on constitutional legality. So we'll just put that there now in that position. They represent the state's legal position even when constitutional concerns are contested. Now that's a very difficult position for an Attorney General, I think, because if they have to advise the government on what happens if they were not asked for the advice, say, on constitutional legality of something, and then they're forced into a situation where they have to defend laws and executive action. Well, that could be very problematic for a moral Attorney General, for example, well, a man of integrity, say they represent the state's legal position even when constitutional concerns are contested. So that's a difficult one for an Attorney General, kind of morally and from a point of view of integrity and in terms of duties. In electoral matters, this means the Attorney General typically defends the existing electoral framework and resists constitutional challenges that could disrupt electoral outcomes. This is not misconduct, it's structural alignment with executive power. However, if, say, there was a situation where a situation arose where the Attorney General was not asked his advice on constitutional legality, then that could be problematic, because he would then have to defend enacted laws and executive action. That's it, executive action. That's really what we're talking about here. So I could see that being very problematic for an Attorney General. You know, if perhaps maybe an Attorney General was not consulted, but I don't know. In this case, you know, did this happen? I have no evidence one way or the other. So this represents the state's. So I can see the point here. They represent the state's legal position even when constitutional concerns are contested. So they have to defend the legal position even if, say, they weren't consulted on an action asked for the constitutional advice, and even if they were asked for the constitutional advice, sometimes they give the right advice, sometimes they're unduly deferential to the state. You know, this can happen as well. So it's a very difficult role in that regard. You know, it's a very delicate balancing act being the Attorney General. Very, very difficult when you see those kind of, I was say competing responsibilities, but very difficult responsibilities. You're kind of stuck in the middle in that sense. I can see it now. Yeah, very difficult. So they represent, in electoral matters, this means the Attorney General typically defends, no matter what, the existing electoral framework and resists constitutional challenges that could disrupt electoral outcomes. That they're forced to do it even supposing if they knew, you know, that they were forcing something which was, you know, constitutionally questionable. Say, I'm not saying this that, but that's a possibility. This is structural alignment with the executive power, which is what's their role. That's part of their role there, as defined. What this means for elections. Elections in Ireland are administered by the executive under legislation passed by the Oireachtas. So the Oireachtas now is the Dáil in the Senate, you know, like the majority. The President plays no role in supervising elections, validating results or adjudicating disputes. The Attorney General does not oversee elections but becomes central once elections are challenged in court. At that point, the Attorney General defends the state, procedural objections are raised and courts are urged towards restraint, finality and not intervention. This places enormous pressure on the judiciary. See that point there? Courts are urged towards restraint, finality and not intervention. If courts, so let's look at that again. So if his role becomes central once elections are challenged in court, at that point the Attorney General defends the state, procedural objections are raised, if they are raised, and courts are urged. This now is again, it's not unique to Ireland. It's an international kind of trend or normalised behaviour or practice, I would say, are urged towards restraint, finality and non-intervention. This places enormous pressure on the judiciary. If courts decide to scrutinise elections before finality attaches, no other constitutional actor can step in. So let me say that again. This places enormous pressure on the judiciary. If courts decline to scrutinise elections before finality attaches, no other constitutional actor can step in. Elections and constitutional finality. Irish constitutional law treats elections as requiring finality, as in other constitutional democracies. Once an election concludes, challenge becomes extremely difficult, if not impossible, even if serious constitutional defects were never examined. If courts allow review on timing or procedural grounds, the election becomes self-validating. Constitutional defects in the electoral process remain untested and therefore can repeat themselves or even get worse, and democratic legitimacy rests on procedure alone. Neither the President nor the Attorney General can correct this. Only judicial adjudication can. Structural non-adjudication in practice. This leads to what can be called structural non-adjudication. Courts manage constitutional risk by narrow standing. Now, again, this is the international picture. So this is mirrored by the Irish practice. Say. So let's not, so courts manage constitutional risk. This is the way it is, and this has become the kind of normalised practice, inverted commas, by narrowing standing, declaring claims non-justicable, allowing delay to defeat review. The most constitutionally sensitive cases, particularly electoral ones, are often filtered out without merits analysis. This is not neutrality, it is institutional risk management with serious constitutional consequence. Why this is a democratic problem. When courts step back, and again this has become more and more normalised over time with this system and this executive kind of breaching. See there with this if you take the balancing actor there is the Attorney General. I'm not saying. I mean, I don't know enough about the reaching into the judicial, putting too much pressure. I'm not saying the Attorney General is doing it, but I'm just saying that part, the executive, is reaching too far in there, putting too much pressure in the judiciary. This is what happens. I'm just thinking, is this what's going on? And it seems to be going on, but I can't say for definite. I mean, I'm not assigning any. I'm just wondering. This is all just wondering. Is this seems to be the pattern that's going on? Why this is a democratic problem? When courts step back due to restraint, all of this judicial pressure, all of this sort of thing, the executive administers elections, the Attorney General defends them, and the President has no intervention power, and constitutional scrutiny disappears. Power remains lawful, but more importantly, unaccountable. This is how democratic systems hollow out, not through overt illegality, but through institutional silence. Who is harmed most? This is my huge thing. The greatest harm falls on ordinary citizens, the squeezed middle, that cannot access legal aid, cannot afford prolonged constitutional litigation, and cannot overcome procedural barriers alone. When only institutions can challenge institutions, the separation of powers ceases to function democratically. What must change in Ireland? These are a few suggestions. To restore constitutional balance, Ireland needs, these are for consideration: expedited judicial review for electoral constitutional challenges, broader standing for structural constitutional harm, recognition that the delay itself can violate the Constitution, protective cost issues in constitutional litigations, and clarity that elections are not constitution-free zones. Also, I think the timing, I think 21 days, I think that timing, that gives very little time for the system to work in practice. So that will be another issue I'll raise there. These reforms are just a number of possible reforms, strengthen, not weaken democracy. Reframing constitutional responsibility. This is another major issue that I've identified. The President safeguards the Constitution before law takes effect. The Attorney General advises and defends the state. Neither can replace judicial scrutiny. That responsibility rests with the courts. Courts must act as constitutional stewards, not risk managers. But you see, the more and more the executive reaching that system, kind of that triangle reaches into the judicial branch, the more the risk, the less the courts retain their power of constitutional stewardship, and the more they become risk managers who are kind of, I'm not saying acting, but are being, I won't say manipulated by government, but are being influenced or whatever, are being pressurized by government, allegedly. But this is, again, it's not unique to Ireland. It's all part of a pattern of the system of separation of powers breaking down over time. in Western democracies. Stability without accountability is not constitutional stability. Conclusion. The Irish separation of powers was designed to prevent the concentration of authority, including electoral authority. When courts decline review, no other constitutional actor can step in. That's the point here. If elections cannot be constitutionally scrutinised in real time, democracy may survive in form while weakening in substance. Restoring separation of powers is not radical, it is essential. So there's just a quick overview of what the separation of powers is, and to show and to kind of give some indication or some insight into how it is gradually being eroded over time, quietly, weakening, and there's this erosion over time, not just in Ireland, and there is a particular vulnerability in elections, and that is critical. That is examined very carefully. That's a critical blind spot for ensuring for the separation of powers to act in accordance with the Constitution. So there are some very complex issues here, and I'm only touching on some of the less complex ones. But I hope this video has been usefully and informative. Thanks to everybody. I'm still trying to secure funding for my Separation of Powers Defend Democracy campaign, and if anyone wants to donate anonymously to that fund to support democracy, €10 would be great. I'd be delighted, and we've been working extraordinarily hard to try, and we're working very hard on various issues at the moment. It's extremely challenging academically, very, very challenging academically, legally, everything. I mean, the amount of the work that's gone into it is it's monumental work, and the concentration you need, the levels of concentration you need to understand the complexity is huge. It's absolutely huge, and the editing is just go on forever. But there's a time to draw the line in the sand, and to say enough is enough. And you one person, it's as I always say, it's way too much for one person or even two. But if you're a lay litigant against the state, which every legal team in the country, they have the power, the money, they have everything. But do they have the truth on their side? That's the question. Do they have the truth? That's the question. And will the truth win in the end? It all remains to be seen. But this is not just an issue unique to Ireland. This has now grown into something much bigger than a democracy problem in Ireland, way bigger. And that's why it's very interesting. And in some ways, it's an ingenious, in my opinion, an absolutely ingenious case. And very interesting to see where we'll go from here.